can't go in there.
I have a scheduled proceeding at 8:30.
Person.
I'm authorized. I am more than authorized. I have my judicial credentials, if you'll allow me to reach into my...
Lady, I said step back. Keep talking and I'll have you removed from the steps.
You don't have that authority.
At 7:58 a.m. on a Wednesday in April in Memphis, Tennessee, a woman was physically blocked from entering the Odell Horton Federal Building on South 3rd Street, the federal courthouse where she had presided over 340 cases in the past 9 years, where her portrait hung in the second-floor hallway, where her name appeared on the building directory beside the words, United States District Court, Western District of Tennessee, by a courthouse security officer who had decided, before she reached the top step, that she did not belong there. Her name was the Honorable Claudette Marie Fontenot. She was 56 years old. She was a United States federal district judge, appointed by the President of the United States, confirmed by the Senate of the United States by a vote of 81-17. And she had been walking up those steps at 5 minutes to 8 every Wednesday morning for 9 years. She was born in 1968 in the Binghamton neighborhood of Memphis, the eldest of 3 children raised by Reuben Fontenot, a sanitation worker who had been on strike during the week Martin Luther King Jr. came to Memphis in 1968. Who had, in fact, marched, and who spent 31 years collecting the city's garbage without complaint and with enormous dignity, and Ida Fontenot, a woman who cleaned offices in the downtown business district 5 nights a week, and who insisted, against the grain of everything her circumstances suggested was practical, that all 3 of her children would go to college. She put that insistence in writing on a note card she kept taped to the kitchen cabinet. This family does not stop at high school. As the note card was still there when Claudette was confirmed to the federal bench. Reuben took a photograph of it the day the Senate voted. He sent the photograph to everyone he knew. Claudette graduated second in her class from Melrose High School in 1986. She received a full academic scholarship to Fisk University in Nashville, where she studied political science and history, where she joined the Pre-Law Society in her first week, and where a constitutional law professor named Dr. Harold Ames told her in her sophomore year that she had the most precise legal mind he had encountered in 22 years of teaching. She graduated magna cum laude in 1990. She attended Vanderbilt University Law School on a merit fellowship, made law review, and graduated first in her class in 1993. She clerked for a Sixth Circuit judge for 2 years, joined the Shelby County Public Defender's Office, spent 6 years trying cases on behalf of people who could not afford lawyers, and then spent 13 years as a professor of criminal procedure and constitutional law at the University of Memphis Cecil C. Humphreys School of Law, where she was named a distinguished professor in 2009 and where her students consistently described her in evaluations, using variants of the same phrase. She makes the law feel like something real. She was nominated to the federal bench in 2014. At her confirmation hearing, a senator asked her what she believed the purpose of a federal judge was. She said, "To make sure the law applies to everyone. Not most people. Not the people who can afford to make it apply. Everyone." In 9 years on the bench, she had presided over civil rights cases, corruption cases, employment discrimination cases, and criminal trials. She had issued rulings that were appealed and upheld. She had written opinions that were cited by other federal courts in 7 different circuits. She had never been reversed on a constitutional question. She had a reputation among the attorneys who practiced in her court for 2 things: absolute fairness and absolute intolerance for any motion, argument, or behavior she considered designed to obscure the truth rather than locate it. Her one core principle, stated in every law school commencement address she had given in the years since her appointment: the courtroom is the last room in a society where facts are supposed to matter more than power. Protect that room. On the morning of April 9th, she had woken at 5:15 a.m., brewed coffee, now reviewed the case files for 2 matters scheduled that day, a suppression hearing at 8:30 and a sentencing at 2, and eaten toast at her kitchen table while annotating a brief. She had dressed in her charcoal suit with a cream blouse. She had driven herself downtown, as she did every Wednesday, and parked in the judicial parking structure on the building's south side. She had walked around to the main entrance at 7:56 a.m. because she had a habit, unbroken in 9 years, of entering through the front doors rather than the judicial entrance because she believed, and had said so, that a judge who only ever entered through a private door eventually forgot what the public doors felt like. She was carrying a leather briefcase that had belonged to her father. He had bought it for her the day she was sworn in. He had died 14 months later. She carried it every day. She was on the 4th step from the top, briefcase in her right hand, when Officer Calvin Dodd stepped in front of her. Calvin Dodd was 39 years old. He had worked courthouse security for the Federal Protective Service for 11 years. Before that, he had spent 4 years as a security officer at a private commercial complex in Germantown, Tennessee, where he had accumulated 5 complaints from employees and visitors, all targeting black individuals, all alleging stops or confrontations without basis, all dismissed following brief internal review. He had moved to the Federal Protective Service in 2013 with no disciplinary flag in his file, and a letter from his prior supervisor describing him as thorough and attentive to potential security concerns. In 11 years with FPS at the Horton Federal Building, he had accumulated 9 complaints, 8 named black individuals. 6 described the same behavioral pattern, a black person approaching or entering the building in professional attire who Dodd challenged, delayed, or denied entry to without lawful basis, dismissing or ignoring their credentials. In one complaint filed in 2018 by attorney Bernard Tate, a 52-year-old civil rights lawyer who had practiced in federal court for 24 years, Dodd had demanded that Tate remove his suit jacket for an additional search after he had already cleared the magnetometer, more stating that Tate had fit a profile. Tate had filed a written complaint. It was dismissed when Dodd's supervisor noted that secondary screening at officer discretion is within operational guidelines. All 9 complaints were dismissed. Dodd received a performance commendation in 2016 and again in 2020 for maintaining building security protocols. He was regarded by his supervisors as diligent and, in the specific language of one evaluation, appropriately skeptical. No one had ever reviewed his complaint history as a pattern. No one had ever placed those 9 files side by side and looked at what they had in common. The system had accepted each one as an isolated incident and moved on. His partner that morning was Officer Steve Halloran, 44, 12 years with FPS, no complaints. A man whose defining professional characteristic was that he never initiated anything and never contradicted anything. The junior officer positioned at the interior checkpoint, who would witness the confrontation through the glass doors, was Officer Dana Reyes, 28, 14 months on the job, who had come to courthouse security from a paralegal position she had held for 3 years, and who understood, better than most people standing in that building, exactly who was walking up those steps. Dodd had seen Judge Fontenot from the top of the steps. She was walking up from the south corner of the building rather than the judicial entrance on the north side. She was in civilian clothes, a suit, not robes. She was carrying a briefcase. She was a black woman walking toward the main entrance of a federal building at 7:58 in the morning. Yeah, and Dodd had made his determination before she reached the 4th step. He stepped in front of her and said she couldn't go in. She told him she had a proceeding at 8:30. He said authorized personnel only. She told him she was authorized. He asked for a badge or clearance card. She said she had judicial credentials and reached toward her briefcase. He told her not to reach for anything. She told him this was her courthouse. He told her to keep talking and he'd have her removed from the steps. She said, "You don't have that authority." He said, "Try me." She looked at him for a moment. Then she set her briefcase on the step, opened it without hurrying, and removed her judicial credentials. A laminated card with her photograph, her name, her title, the federal seal. It was and the words, United States District Judge. Anne held it in front of him at eye level. He looked at it. He looked at her. He said, "This could be a fake." She said, "It is not a fake." He said, "I'll need to verify. Wait here." She said, "I will wait exactly as long as it takes you to read what is printed on that card. My name is Judge Claudette Fontenot. I have a proceeding that begins in 32 minutes in courtroom 4B. You are currently detaining a federal judge on the steps of her own courthouse." He said, "Ma'am, I'm doing my job." She said, "Then I'd encourage you to do it correctly." He called for backup on his radio. He told her not to move. She did not move. She stood on the step with her briefcase open, her credentials in her hand, and her eyes straight ahead, in the specific stillness of a person who has learned that over a long professional life, that composure is not the absence of anger, but its most precise deployment. 4 cameras recorded what happened on those steps. The first was the FPS exterior camera mounted above the main entrance, aimed at the steps and the approach walkway. It captured Dodd's positioning before Fontenot reached the top. He had moved to the center of the entrance before she was within speaking distance, which meant the decision had been made before any interaction occurred. It captured her presenting credentials. It captured Dodd looking at the credentials and stepping back rather than stepping aside. The second was the interior checkpoint camera operated by Officer Dana Reyes, which had a sightline through the glass doors to the steps. It captured Reyes's face as clearly as it captured the scene outside. and A. Dana Reyes's expression, preserved in that footage, would later be described by senior investigator Marcus Webb of the Department of Justice Office of Inspector General as the expression of someone watching something they already know is catastrophically wrong. The third was the cell phone of Dr. Patricia Osei, 61, a professor of federal courts and procedure at the University of Memphis Law School, who arrived at the steps at 8:02 a.m. for a 9 a.m. hearing where she was serving as an expert witness. She recognized Judge Fontenot instantly. She began recording without hesitating and without speaking. She would later testify that she had spent 30 years teaching federal procedure and had never, in those 30 years, seen a federal judge blocked from entering their own courthouse. Warrior IV was the cell phone of Command Sergeant Major Dwight Beaumont, retired, 69, who had served 27 years in the United States Army and was at the courthouse to file paperwork in a veteran's benefits appeal. He had no prior connection to Judge Fontenot. He began recording because, as he would tell investigators, "I know what it looks like when someone in authority is treating a person without authority like they have to earn the right to exist in a space. I've seen it on 3 continents. I recognize it every time." At 8:06 a.m., Dodd's backup arrived in the form of his supervisor, Shift Commander Roy Tasker, 51, who came through the interior doors and stepped outside. Tasker looked at the scene. A black woman in a charcoal suit standing on the courthouse steps holding federal judicial credentials. 2 officers, May, a professor with a phone up, a retired soldier with a phone up, and 4 other bystanders watching, and said, "Calvin, what is this?" Dodd said he was verifying credentials of a person claiming to be a federal judge. Tasker looked at the credentials. He looked at the photograph on the credentials. He looked at Judge Fontenot. He looked at the photograph again. He said, "Calvin." That was all he said. Dodd said, "Sir, she came in from the wrong entrance." Tasker said nothing. He turned to Judge Fontenot and said, "Your Honor, I apologize. Please come in." She had been standing on those steps for 11 minutes. She said, "Thank you, Commander." She walked through the doors. She took the elevator to her floor. She went to her chambers, put on her robe, and at 8:31 a.m., 1 minute late, it stays extra starten wife is for the first time in 9 years, she took the bench. She did not mention what had happened on the steps. The attorneys in courtroom 4B noticed she looked, as one later described it, like a person carrying something very heavy, very carefully. But she ran the suppression hearing with complete precision, as she always did, and she issued a ruling from the bench at 10:14 a.m. that was legally airtight and would not be appealed. On the steps behind her, Officer Dana Reyes had watched the whole thing through the glass. When it was over, when the judge had gone inside and the bystanders had dispersed and Dodd had walked back to his post as though nothing had happened, Reyes had stood at her checkpoint for a long time. Then she had gone on her break. That she had called the DOJ Office of Inspector General hotline from the parking garage stairwell at 8:47 a.m., before the judge's suppression hearing had even concluded, and said, "I need to report an incident that happened 12 minutes ago on the front steps of the Horton Federal Building, and I need to know if I have whistleblower protection before I say anything else." They told her yes. She said everything. Have you ever watched someone be told they didn't belong in a place they had given their life to? What does it cost a person to walk through that door anyway? The calls began before Judge Fontenot had finished her morning hearing. At 8:19 a.m., while she was still on the steps, This Patricia Osei had called the clerk of court's office and left a message stating that a federal judge was being detained at the main entrance by security personnel. The deputy clerk who received that message at 8:22 a.m. went directly to the chief judge's chambers. Chief Judge Warren Aldis, 63, 17 years on the federal bench, received the information at 8:24 a.m. He called the Federal Protective Service District Commander at 8:26 a.m. The call lasted 90 seconds. The district commander's voice, by second report, changed somewhere in the middle of it. At 8:31 a.m., the district commander called the FPS regional director. At 8:34 a.m., the regional director called the Department of Homeland Security's Office of Inspector General. At 8:41 a.m., the DOJOIG received the whistleblower call from Dana Reyes and opened a formal investigation. At 9:05 a.m., the U.S. Attorney for the Western District of Tennessee received a call from Main Justice in Washington. He said later that the person on the other end of that call, a Deputy Assistant Attorney General he had worked with for 14 years, had a quality in her voice he had never heard before. He described it as the specific alarm of someone who cannot believe they are saying the words they are saying out loud. Dodd filed his incident report at 2:17 p.m. It contained the following specific false statements. He wrote that he had observed an unidentified individual attempting to access a restricted federal facility through the public entrance without presenting valid credentials upon initial approach. He wrote that the individual had been uncooperative and escalatory in manner. He wrote that he had followed standard protocol for unverified entry attempts, and that the matter had been resolved through supervisory intervention with no further incident. He did not mention the judicial credentials. He did not use the words federal judge. He did not mention that the individual had presented identification or that he had examined it and questioned its authenticity. He found Halloran after filing and said, "Keep it clean. Unverified entry attempt. It's a standard protocol." Halloran filed a supplemental report that corroborated Dodd's version and added nothing. That same afternoon, Dana Reyes was formally interviewed by DOJ investigators. She had already called the hotline. She told them everything, and she told them where to find what the cameras had recorded. The DOJ Office of Inspector General's technical unit synchronized 4 video sources into a single master timeline over the course of 6 days. The resulting composite file ran Dodd's incident report text on the left side of the frame and the corresponding footage on the right, second by second. Investigators identified 17 direct contradictions between the report and the visual record. The moment that would become the most replayed clip, captured simultaneously by the exterior entrance camera and Dr. Ose's cell phone from 2 different angles, occurred at 8:04 a.m. It showed Dodd holding Judge Fontenot's judicial credentials in his hand, looking at them, looking at her, and saying, "Half the people who come in here with fancy cards think they own the place." Dr. Ose's phone captured the audio with particular clarity because she had been standing 6 feet away. The exterior camera captured it from above. Both recordings were synchronized and time-stamped. The clip was 11 seconds long. It was played in the federal grand jury room on a Monday in July. The foreperson later told investigators that after the clip finished, a juror in the back row said, quietly, "He knew." Nobody disagreed. Nobody needed to hear anything else after that. They heard it anyway, all the evidence procedurally, as required. But that clip was the room. A senior investigator, Anita Chukwu, 21 years with the DOJ OIG, filed her summary report on August 3rd. The operative sentence, subsequently quoted in the criminal indictment, the civil complaint, 4 motions, and twice on the floor of the Senate Judiciary Committee, read, "Officer Dodd did not fail to recognize a federal judge. He recognized her, determined that recognition was insufficient reason to alter his course, and then constructed a written record designed to make that determination disappear." The federal grand jury returned a 3-count indictment against Calvin Dodd on September 11th. Count 1. Deprivation of rights under color of law, 18 U.S.C. Section 242, for the unlawful detention of a sitting federal judge at a federal courthouse, motivated by race. Count 2. Making false statements in a matter within federal jurisdiction, all 18 U.S.C. Section 1001, for the fabricated incident report. Count 3. Obstruction of a federal proceeding, 18 U.S.C. Section 1512C, for physically impeding a federal judge's access to her courthouse on a day when federal proceedings were scheduled to occur under her authority. Dodd rejected all plea offers. He went to trial in February. On the 3rd day, under cross-examination, he testified that he had not been certain the credentials were genuine. He testified that the judge had been aggressive in manner. He testified that his incident report was an accurate reflection of his understanding of events. He testified that any gaps between the footage and the report were the result of the inherent limitation of camera perspectives. The prosecution played the composite file, all 41 minutes, without interruption. The jury deliberated for 3 hours and 55 minutes, guilty on all 3 counts. At sentencing, United States District Judge Raymond Ose, brought in from the Southern District of Ohio to avoid any appearance of partiality, looked at Calvin Dodd across the courtroom for a moment before he spoke. Then he said, "You stood at the entrance to a federal courthouse and decided, before a word was spoken, that the black woman walking toward you did not belong inside it. When she showed you proof that she belonged there more completely than almost anyone alive, that she had been entrusted by the President and the Senate with the authority to interpret federal law in that building, you looked at that proof and invented a reason to distrust it. Then you wrote a report that tried to make all of that vanish. You did this not because you made an error. You did this because 11 years of dismissed complaints had taught you that the institution would absorb whatever you did. You were right about the institution's past. You were wrong about its future. Calvin Dodd was sentenced to 41 months in federal prison, 3 years of supervised release, and a lifetime ban from any employment in federal security, law enforcement, corrections, or any role exercising government authority over individuals. Share this. Institutional accountability only happens when the record stays visible. The record stays visible when people refuse to look away. The Federal Protective Service settled the civil rights lawsuit filed by Judge Fontenot in her private capacity, separate from her judicial role, and represented by outside counsel. On a date 47 days after the criminal verdict, the settlement totaled $6.8 million, described in the DOJ's official press release as the largest civil rights settlement in Federal Protective Service history. As a condition of settlement, the FPS agreed to implement mandatory judicial and attorney credential recognition training for all courthouse security personnel, renewed annually, to establish an independent civilian review panel with authority to audit all complaint records for pattern evidence, with findings reported publicly on a quarterly basis, to require collective review of any officer's complaint history whenever a third complaint is filed, rather than treating each complaint as procedurally isolated, and to prohibit any security officer from questioning or delaying entry of an individual who presents valid federal judicial credentials under any circumstances except a credible and documented security threat. Judge Fontenot directed $2.1 million of the settlement into the Ida and Reuben Fontenot's Public Interest Law Fellowship, which would fund 3 law school graduates per year to spend 2 years in public interest legal practice in Memphis, with preference given to graduates of Fisk, Spelman, Howard, and Morehouse. The fellowship was named for her parents. Her mother called her when she heard the name and cried. Her father could not call. His briefcase was in Claudette's office on the hook beside the door, where she could see it from the bench. Calvin Dodd began serving his sentence in April. His federal pension, 11 years accrued, was forfeited under federal statute governing felony conviction of federal employees. His wife filed for separation 3 weeks after the verdict. He will be 44 at the conclusion of his sentence. Steve Halloran received a 60-day suspension without pay, mandatory retraining, and a permanent notation in his file. He returned to duty in a non-public contact role, processing internal documentation. Dana Reyes received full whistleblower protection, a formal commendation from the DOJ Inspector General for integrity under institutional pressure in service of the rule of law, and was promoted to senior officer. She later enrolled in a paralegal certification program with the intent of returning to law. Judge Fontenot wrote her a letter of recommendation. Shift Commander Roy Tasker, who had failed to report the incident through official channels and whose own handling of 3 prior Dodd complaints was found to have been inadequate, received a formal demotion and a mandatory 18-month supervisory review period. 4 additional FPS supervisors whose names appeared on dismissed Dodd complaint letters received administrative review. 2 retired under negotiated agreements before the process concluded. 2 remained and were placed in non-supervisory roles for a mandatory period of 24 months. Dr. Patricia Ose was recognized by the Memphis Bar Association in June with its annual Civil Rights in Practice Award. In her acceptance remarks, she said she had spent 30 years teaching students that constitutional law mattered. And that standing on those steps with her phone up was the first time in those 30 years that she had tested that belief in real time and found out whether she actually meant it. She said, "I did. I hope my students do too." Command Sergeant Major Dwight Beaumont received no formal recognition and did not seek any. He attended the verdict. When it was read, he nodded once, the way a person nods when something they already knew is confirmed. He went home. His Veterans Benefits appeal, for which he had originally come to the courthouse that Wednesday morning, was resolved in his favor 4 months later. He did not connect the 2 things publicly, though people who knew him said he found the timing quietly satisfying. Judge Claudette Fontenot returned to the bench the Thursday after the incident, as she had always done. She ran her cases. She issued her rulings. She wrote her opinions with the same precision she had always brought to them. She changed in one specific quiet way. From that April forward, every Monday morning, she entered through the main entrance. Not the judicial entrance, not the underground parking connection, not the side corridor her law clerk had started using to help her avoid the front steps. The main entrance, up the steps, through the public doors, past the security checkpoint, past whoever was stationed there. She nodded to the officer on duty every time. She showed her credentials every time, voluntarily, without being asked, holding them up long enough for the officer to see her face and the card both. She had decided that she would not let what had happened on those steps make her avoid those steps. That she had decided that walking through the front door every week in plain sight was itself a form of testimony. That showing up was itself a statement of what she believed the courthouse was for. It was not a dramatic gesture. Nobody wrote about it. She never mentioned it. But every officer who worked that checkpoint came to know her face, her name, her briefcase, the worn leather one, and the specific way she came up the steps at 5 minutes to 8 on Monday mornings, unhurried, straight ahead, as though there was no question in the world about where she was going. On the plaza of the Odell Horton Federal Building, on a cool morning in early November, Judge Claudette Fontenot made one public statement. She had declined all media requests for 4 months. She made one statement on one day, in one place, and she did not repeat it. She spoke for 7 minutes. She did not raise her voice. She thanked Dr. Osei, who had recorded without being asked, and who had spent 30 years teaching people that the Constitution was worth protecting and had proven, on a Tuesday morning in April, that she had been telling the truth. She thanked Command Sergeant Major Beaumont, who had recognized something from a great distance and had the discipline to preserve it rather than confront it. She thanked Dana Reyes by name. Reyes had said she was glad to be named, and said that what Reyes had done before the investigation even existed, in the parking stairwell at 8:47 in the morning, was the definition of civic courage, and that civic courage was rarer than it should be and should never be taken for granted. She talked about her father. She said he had carried garbage through the streets of Memphis for 31 years, in heat and cold, and that people had driven past him every day without looking, not because he was invisible, but because they had chosen not to look. She said the courthouse was supposed to be the place where that choice was not permitted, where looking was mandatory, where the record had to reflect what actually occurred, where you could not drive past the truth and call it policy. She said that was what she had spent her professional life trying to protect, and what she intended to spend the rest of it protecting. She said she was not going to ask anyone to be outraged. She said outrage was available every day and it faded, and it left people exhausted. What she wanted was something less dramatic and more durable. She wanted collective insistence that the record be accurate, that complaints be reviewed not in isolation, but as the patterns they were, that institutions be required to look at what they were producing rather than simply absorbing it. She said the words record and accountability multiple times. She said dignity once, near the end. She did not use the word justice until the final line. She said, "I walked up those steps 11 years ago for the first time in a robe I had not yet earned, and I thought about my father, who earned everything he ever had through labor that nobody celebrated, and I made a promise to him and to this courthouse and to everyone who would stand in it, that in my courtroom the facts would matter more than the power, every time, without exception, without favor, and without the requirement that a person prove themselves worthy of what the Constitution already guarantees them. That promise is what was tested on those steps in April. That promise is what I am here to tell you is still standing, and that, only that, is justice." She stepped back from the microphone. She took the steps. She went inside. She went up to her floor. She put on her robe. She had a sentencing at 1 o'clock. The last paragraph of her statement, from "I walked up those steps" to "is justice," was used in full as the epigraph to the Federal Protective Service's revised credential recognition training manual, distributed to every FPS district in the country the following year. A student at the Memphis Academy for Advanced Studies, a 16-year-old named Josephine Carr, Mice included the final 2 sentences in a civics competition essay she submitted that spring. The essay, titled "Still Standing," won the Tennessee state competition and was read at the state capitol by the student herself in front of the full legislature on a Thursday morning in March. And the 6 words at the end, "That promise is still standing," were carved into the granite wall beside the main entrance of the Odell Horton Federal Building, below the building's name, at the request of Chief Judge Warren Oldys, approved by the General Services Administration, installed on the first anniversary of the incident. At the unveiling, Judge Fontenot stood on the steps where it had happened, in the same charcoal suit, holding the same briefcase, and looked at the words for a moment. Then she looked at the door. Then she walked through it.